So there's a lot of confusion around Medicaid, what you can do, what's allowed, what's needed to qualify, what it covers, and some information you may get may not be applicable to you. Everybody's situation is a little bit different. So we can go over what Medicaid is. And if you certainly have any questions going through all of this, let us know and we'll attempt to answer those questions. We can really take it in any direction that you want. So one confusing thing that people may or may not be aware of is Medicaid versus Medicare, right? So they're two different programs. So Medicare is the federal health insurance program for those individuals who are age 65 or older, or if you are considered disabled, or individuals with end-stage renal disease. So this is the program that provides for health insurance. So if you've paid into the system, then you're entitled to Medicare once you reach a certain age, or if you have a disability. Medicaid, on the other hand, is actually a needs-based program. So you have to meet certain requirements. You have to be age 65 or older, or disabled, or blind, and you have to then also meet some asset and income limitation tests. Whereas Medicare, you don't have to meet those tests. Medicare is the insurance that you're entitled to, again, if you paid into the system. Medicare covers Part A and Part B. Everybody's heard of these different parts. So Part A being hospital insurance, inpatient hospital stays, hospice care. Part B is the medical insurance, which covers your doctor's visits, outpatient care, medical supplies, things like that. And then Part D, everybody knows about the prescription insurance. And then Part C is your Advantage plan. That's an alternative to the original Medicare. So it's a bundled plan that would include Parts A, B, and Part D as well. So Medicare does not pay for long-term care. Medicare will pay up to 100 days if a person is in a skilled facility in rehab, and they qualify for that. So to qualify for that, you have to be admitted to the hospital for a period of at least 3 days. So not just under observation, you actually have to be admitted for 3 days. And then you have to enter into the facility within 30 days for the same reason or condition that you were in the hospital for. Then Medicare will pay up to 100 days. Doesn't mean that you're going to get the full 100 days. Just means that they won't pay past 100 days. And quite frankly, most people don't get 100 days because it's rehab. So once you stop progressing, then Medicare is going to issue a cut letter where they're not going to pay anymore. So days 1 through 20 are paid in full. And then days 21 through 100, or whenever you get cut, there is a copay per day by the patient, which may or may not be picked up by your supplemental plan if you have a supplemental plan. Medicaid pays for long-term care. So a long-term stay in a nursing home setting or an assisted living setting, or you can also get Medicaid at home for in-home care services. If you're receiving in-home care services through Medicaid, they will pay up to about 40 hours a week for in-home services. Now, if you need anything over and above that, then you would likely have to pay privately for that, utilizing your income or some other source. So let's go over the eligibility requirements for Medicaid. So the rules will differ slightly depending on whether the individual is single or married. But what Medicaid looks at is they look at assets and they look at income. So an asset is anything that the applicant owns or anything that has any value. With regard to assets, some assets are countable, some assets are not countable, so some may be exempt. All the other ones will be a countable asset, which will go towards your asset limitation, again, depending on whether you're single or you're married. And then they also look at income, which we'll get into in a little bit as well. So what's a countable asset? So that's going to vary a little bit if you're married or if you're single, but cash, bank accounts, investment accounts, 401ks, IRAs, annuities, CDs, second pieces of real estate, rental properties, second vehicles, all of these are going to be considered assets. Now, some of the assets could be exempt, again, depending on the situation. Now, if you're single and you're applying for Medicaid, there's an asset limit of $2,000. So you cannot have more than $2,000 in your name at the end of the month and still apply or still be eligible for Medicaid the first of the subsequent month. Now, if you're a married couple and you both are applying for Medicaid, then the limit is $3,000. So myth one, single applicant. I have to get rid of all of my assets in order to be eligible for Medicaid, which is not correct. You don't have to get rid of everything, right? And it also depends on where you're receiving Medicaid benefits. So you can have a prepaid funeral. It needs to be in an irrevocable funeral trust. So these are funds that are paid in advance to cover your burial expenses, burial plot, headstone. Fortunately, they let you keep your wedding band, your engagement ring, personal effects, small life insurance policies. So life insurance where the total combined face value is $1,500 or less, then the cash value does not count. So if you have a life insurance policy that's $1,500 face, the cash value, regardless of the amount, doesn't count toward that $2,000 limit. So if it has a cash value of $2,500, it's not going to count, right? Now, you can have a single life insurance policy that's $1,500. You can have one policy that's $1,000 and another policy that's $500. But if the combined face value of all the policies are more than $1,500, then the cash value of all the policies are going to count unless you get rid of some of the policies and then bring that face value down to $1,500 or less. Now, everything else is going to count. But that being said, if you're at home and you're receiving Medicaid benefits, then you're obviously allowed to keep your home as well. Now, what if you're married? If you're married, it's pretty much the same, except that the property is obviously protected for that spouse that's remaining at home. So if one spouse is going into a facility and the other spouse remains at home, then obviously the residence is going to be a protected asset. It's not going to be a countable asset towards that Medicaid applicant that would disqualify them. But one of the things that we want to do here is we want to make sure that home stays protected, because most properties, if it's a married couple are held as tenants by the entirety. They're held as jointly as husband and wife. And if, let's say that the husband is going to be on Medicaid and the home is held jointly, if you don't retitle the home to the wife, then if the wife unexpectedly passes away, now we have a piece of property going to the husband that's on Medicaid. And then Medicaid's going to say, okay, now you need to sell that property. You'd have to spend down all the proceeds, come off of Medicaid. And then once all of those proceeds are spent down, then you can go back on Medicaid again. So that's not a good planning scenario. So ideally, what we'd like to do is take the Medicaid applicant's name off of the deed and put it into the community spouse's name alone. And then we have to look a little bit further, right? Because the will of the wife that's staying at home probably says, I leave everything to my husband, depending on when it was done. So we want to make sure that we go a step further and we check that will and make sure that we're not leaving everything to the spouse that's on Medicaid in a facility. So we want to make sure all of that's taken care of.
Chris, quick question.
Yep.
Curiosity asset question concerning Medicaid. At what point in time were the dollar asset figures set, and is that ever revisited?
For a Medicaid applicant or spouses? So for the Medicaid applicant, the $2,000 limit, I honestly don't know. I've been practicing for 19 years, and for 19 years, it's been $2,000. So that has not changed. Now, if you're married, which we're going to get into in just a second, and we're talking about the community spouse resource allowance, what the spouse is entitled to keep, that changes, I think it's every January. So that just went up, actually. So that's revisited every year.
Okay, so hopefully that answered your question, Roseanne and Paul. If not, please let us know, what else we can answer for that piece.
Okay, myth number 2, if my spouse is going on Medicaid, but I'm not, I still have to spend down all of our assets, which is not correct. So the community spouse is the spouse, the well spouse, the spouse that's remaining at home, and then we have the ill spouse, the Medicaid applicant that may be going into a facility. So there's something called a snapshot date, and the snapshot date determines what the community spouse resource allowance is. The community spouse resource allowance is the amount of money that the community spouse is entitled to keep, the amount of assets. The snapshot date is the first day of the month in which the Medicaid applicant entered into a facility, which can include a hospital, and then did not return home. So if the Medicaid applicant entered into the hospital on February 15th and then went to rehab and then is now going to stay in long-term care, then your snapshot date is February 1st. So Medicaid looks at all of the assets as of February 1st, and it doesn't matter whether it's in his name, her name, joint names, her name, joint with the child, it doesn't matter. If the spouse is on the account and or the Medicaid applicant is on the account, that's what Medicaid is looking at to determine what that community spouse resource allowance is. That's your snapshot date. Then from there, we determine how much has to be spent down. So anything in excess of the community spouse resource allowance either has to be spent down, or you come to us and we help you protect some of those assets. So the community spouse is entitled to keep half of all of the countable assets, but it's subject to a maximum. That maximum for this year is just over $130,000. And the minimum is a little over $26,000. So if the total assets of the couple were $200,000 as of the snapshot date, then the community spouse is entitled to keep $100,000. That's one half. If the total assets of the couple is $500,000 as of the snapshot date, then the community spouse is entitled to keep a little over $130,000, right? Because it is subject to that maximum. So they don't get to keep the $250,000. It's maxed out at a little over 130. It's $130,380. So that's the max. So that other $370,000 or so is what's at risk. So what are you going to do with that? Is that going to be spent down at the facility, or we're going to try to protect some of that for the community spouse so they're not left with just $130,000 for the rest of their life? Those are all things that you're going to have to make a personal decision on. And then there's also something called a minimum monthly maintenance needs allowance, MMMNA. So that's the amount that the community spouse is entitled to as a minimum amount of income. And it's $2,115 for 2021. So if the gross income of the community spouse is not $2,115, then they can pull from the income of the Medicaid applicant to bring them up to an amount that would reach at least the minimum monthly maintenance needs allowance. Now, depending on what your expenses are, it could go a little bit above that as well. That's a different calculation.
Chris, there's a question. So if your house is worth $130,000, you can't keep your other assets?
Now remember, the home was exempt. So there are exempt assets and non-exempt assets. So if you're a married couple and the community spouse is living in the home, that's an exempt asset. So that the value of that home will not be counted toward these assets regarding the maximum and the minimum that the community spouse is allowed to keep. That makes sense? Okay, and then we have a look back period. So everyone has heard of the look back period. Medicaid looks back 5 years from date of application. So from date of application back 60 months, they want to see every transaction that is occurring with your financial institution. So what money is going in and what money is coming out. So what we do whenever we're assisting clients with Medicaid is we create a chart of transactions. So we go through all of the account statements, We see what money is going in, what money is coming out. And typically Medicaid will want to identify anything in excess of $500. So whether it's going in or coming out, they want to know what it's for. And then we'll talk about gifting in a little bit, but they want to see everything that's happened. And some clients will ask us, and they'll want to know, well, how's Medicaid going to know what I did during that 5-year period? They will see it on all of the banking transactions. They go through each of the financial institutions' statements for that 5-year period. Now, if your income, remember we talked about assets and we talked about income. If your income is too high, then technically you don't qualify for Medicaid. However, if you have a qualified income trust, then you can qualify for Medicaid. But if you don't put the qualified income trust in place, then you're not going to qualify for Medicaid. So the income limit is $2,382 gross per month. If your income exceeds that, then you have to have this QIT. And the income then has to go into the trust. And it's not just the excess income, it's the entire payer source. So if you have Social Security that is $1,000 a month and you have a pension that's $2,000 a month, either both of those have to go into the QIT or one of them has to go into the QIT to bring the person down below the 2382 limit. But you're going to need that QIT in order to qualify for Medicaid. The requirements of the QIT, it's only the income of the individual. Assets are not placed in there. Investment accounts, checking, savings, IRAs, the income of the community spouse, none of that goes into the QIT, only the income of the applicant. Nothing else. It has to be irrevocable. There has to be a trustee. There has to be a payback provision in there. But in reality, there's not going to be money accumulated in this trust because when the income goes into the trust, it's going to come right back out again. So if the income goes in, let's say that there's $3,000 a month going into the trust. So we have to have a QIT because it's in excess of that minimum amount of $2,300. The $3,000 goes in. The community spouse may be entitled to a portion of that income depending on what the community spouse's gross income is. So they could be entitled to a piece of the income in order to lift their minimum monthly maintenance needs allowance. The applicant is entitled to keep a certain amount of money. That amount of money varies depending on whether the person is in a nursing home, an assisted living facility, or at home. And then if they have like a supplemental insurance policy, that payment can also come out of the trust. And then whatever's left has to be paid over to the facility as part of the cost share. And then Medicaid will pick up the difference. And that's how Medicaid works with regard to their payment. Any money that comes out of that QIT has to be approved. So it can only be spent on certain things. Otherwise, you're going to lose your Medicaid eligibility. So the beneficiary, a guardian, or power of attorney can set up this QIT. Medicaid is going to issue a personal responsibility form, PR1, PR2, or PR3, depending on where the individual is living. So nursing home, assisted living, or in the community. And that personal responsibility form is going to be a calculation that shows the gross income of the applicant, the allowable deductions, so the minimum monthly needs allowance, that's going to go to the community spouse, the personal needs allowance, that's going to go to the Medicaid applicant, the payment to the supplemental health insurance, like United Healthcare or ARP or someone like that. And then whatever's left over, that amount is what is going to be paid over to the facility. So that's your personal responsibility form. A post-eligibility treatment of income is really what we just discussed. So the personal needs allowance, depending on where the person is living, either in nursing home or in assisted living, the community spouse allowance, which is that minimum monthly maintenance needs allowance, health insurance premiums, anything else is going to have to be approved. All right, so this is a big one, gifting. This is where people get tripped up, among other things. So a lot of people believe that they can give $15,000 per year without being penalized. That's incorrect. So that's an IRS regulation. That's not a Medicaid regulation. The IRS says you are allowed to give $15,000 per year per person, and you don't have to file a 709, which is a gift tax return. You don't have to tell the IRS about it. You can give away more than that. You just have to tell the IRS that you're giving it away. As of today, before Biden makes any changes, there is a federal lifetime gift exclusion amount of $11.7 million. So technically you can give away $11.7 million tax-free. Now you have to report it when you give it away to the IRS, and there's not going to be a tax due as long as it's under your exclusion amount, but then you're not going to have an exclusion amount whenever you pass. So if you do still have money left over when you pass, then that's going to be subject to a federal estate tax. Now this number will likely change based on whatever Biden may place into law, and it's due to sunset anyway. So you're probably going to see this number in all likelihood go down to 5 million, could go down to 3.5 million. It just depends on ultimately what Biden decides to do. But again, you can give away up to that amount tax-free. Now that is not applicable for Medicaid purposes. If you give away anything for Medicaid that has value and you don't receive value back, that's going to be considered a gift, which is going to result in a penalty by Medicaid. So if you give away $100,000 in cash, that's a $100,000 gift. That's going to be what the penalty is based on. If you give away your home, the value of the home is going to go into the calculation for the gift penalty. If you think you're going to sell your home for $1 to your child, that's still considered a gift because your child didn't pay actual fair market value for the home. So anything that you give away is going to be considered a gift. If Medicaid finds that there's a penalty, I have to pay the penalty back to the state. A lot of people think this. A lot of people think it's a monetary penalty. It's not. It's a time penalty. It's not something that you have to pay back. It's not something that the state is going to come back for you, back to you to try to get repayment. It's a period of time. So if you apply for Medicaid and Medicaid says, okay, you have a 10-month penalty, that means from essentially your date of application, assuming that you met all the other requirements, which means you have less than $2,000 in your name, right? Because that's a requirement to be qualified for Medicaid. Medicaid would say, okay, for the next 10 months, we're not going to pay. So the problem is then how are you going to pay? Because you don't have any money. Are the children going to pay? Is someone else going to pay? So that becomes a problem. So that's why we want to address any potential penalty before our Medicaid application to receive benefits. So we want to get that done and finished out ahead of time, so we don't have an issue moving forward.
There's a question.
Okay.
Why do you have to tell the IRS if you gift one person more than $5,000?
Okay, it's $15,000.
I'm sorry. It says 15,000. I'm sorry, I read it wrong. Why do you have to tell the IRS if you gift one person more than $15,000?
Because it's an IRS regulation. It's a law. So the IRS says if you give away more than $15,000 per person per year, you have to tell them about it. It's called a 709, which is a gift tax return. You have to fill out this form and you have to send it into the IRS. And then assuming you're claiming your exemption, though, there's not going to be a tax on it unless you've given away more than $11.7 million. So that's an IRS regulation.
There's another question when you're finished.
Okay.
With gifting, how are birthdays, Christmases, and wedding gifts considered by Medicaid? And she said Medicare, but the question really is Medicaid for the person who asked this question. So with gifting, how are birthdays, Christmas, and weddings considered?
Same as anything else, unfortunately. So if it's a gift, then it's going to be considered a gift for Medicaid purposes. That is, if during that 5-year look back period, could result in a period of disqualification. But again, they're really looking, now they can ask for anything, but they're really only focusing on anything of $500 or more, but that's not to say that they can't ask you about a $100 gift or a $50 gift. If it's a gift, it's a gift. Now there is a part of the administrative code that says you can rebut the presumption that it was for Medicaid planning. That's a very high hurdle to overcome, because in general, if Medicaid sees you giving money out, they're going to count it as a gift. Now you can try to say, well, I made those gifts prior to becoming ill. It wasn't done in contemplation of Medicaid planning. In our experience in today's climate and with the state needing money, they're going to consider it a gift and they're going to try to penalize you for it.
Chris, there's more questions.
Okay.
One thing I wanted to say about that too, that Chris and I say often, is that a gift doesn't have to be wrapped in a bow. So that's why Chris is saying we look at everything. And that's part of what we do when we do that 5-year look back, is to make sure that we know where everything went, because people think of a gift as a gift, something wrapped in a bow, and it doesn't have to be that. So one question is, how is the penalty calculated on gifts?
So it's a formula. What they use is the value of the gift divided by what they deem the monthly rate to be in a semi-private room in a skilled setting. So currently that divisor is approximately $10,550. It's an actually per day divisor, because there's, obviously 30 days in some months, 31 days in other months, but an approximation is around $10,550.
Okay, the next question is, can birthday, wedding, baby shower gifts come out of the qualified income trust?
No.
The next one is, sorry for the delayed question, but where do you go to open a QIT?
You can open a QIT in any bank. So whatever bank you choose to conduct your banking at, you can open it there. So whether it's TD, Fulton, BB&T, Wells Fargo, whoever, they can open it there.
And then there's also a question, one of my friend rents a room out to someone. Is the rent that they pay considered a gift?
And this is assuming that your friend is going to be the Medicaid applicant. And we're going to get into this actually. If you make a payment to someone, and again, it could also depend on who that person is, but it could be considered a gift if there's not a lease in place. So we're going to cover that in a little bit. So there should always be a lease in place. If there's a lease in place, it's not going to be considered a gift. If there's not a lease in place, it could be considered a gift.
And I just wanted to go back to that qualified income trust question, because I know that we're covering a lot of things here. The qualified income trust, just to reiterate what Chris said, at the end of every month, there's nothing left in it. It's not a typical trust where you would put money aside. It goes in and it comes out every month. So hoping that also helps with that QIT question. It looks like that's it for right now, Chris.
It's just a vehicle where money comes in and it goes right back out. You're going to open it with like $20, and that's really pretty much all that's going to be in there at the end of every month, is somewhere around that amount.
Okay, you can go ahead. I think we got them all.
Okay. And this is what we just talked about. The length of the penalty is calculated by dividing the amount that was transferred by the average monthly cost of care. And today that's, again, somewhere around $10,550. So as an example, if you give away $100,000, then the penalty is going to be around 10 months, somewhere around that, maybe nine months or so. So how do you avoid a penalty? So you have to get fair market value back for something. So this is especially important with written agreements like we were just talking about, the lease. If you're paying rent, there needs to be a written lease in place. So if mom is living with her daughter and she's paying her daughter $1,000 a month to help offset with utilities and groceries and things of that nature, there needs to be a lease in place. I know it sounds burdensome, and know it kind of flies in the face of most people just using common sense, saying that it's a familiar relationship there. But Medicaid is of the opinion that if there's not a lease, then there's not an expectation of payment. If there's not an expectation of payment, then it's considered a gift. and they will treat it as a gift. If caregivers are being paid, there needs to be a caregiver agreement. There needs to be an expectation of payment. That payment also needs to be in the form of a check. Don't go to the ATM and take out $1,000 and then pay your caregiver, because you can't track where that cash is going. It just makes it more difficult. Now you can try to leave a log. You can then try to go to the caregiver and have the caregiver sign an affidavit. In our experience, that the caregivers typically are not going to want to get involved. They don't want to sign an affidavit. They think you're going to take them to the IRS since they probably didn't report the income. So it's not a good idea to go to the ATM and take out cash to pay somebody. If someone else is advancing funds on behalf of the Medicaid applicant, there has to be a promissory note in place. Again, going back to, there has to be an expectation of payment. So if daughter advanced a certain amount of funds, then the promissory note needs to predate the daughter advancing the funds. Again, there has to be an expectation of payment. Okay, many people just seem to gloss over this and they avoid it, and then it comes back to bite them later. So how do you cure a penalty? As long as some of the gifted monies are returned, the penalty can be mitigated, which is a myth, right? No. You do not get a credit if you do not return all of the funds. So if you give away $100,000, let's say you give $50,000 to your son and $50,000 to your daughter, and then you have to apply for Medicaid, and it falls within that 60-month look back. And the son, of course, spent all of his money, but the daughter kept her money. If the daughter gives back her $50,000, you don't get a credit for that $50,000, meaning the penalty is not reduced by the $50,000. You're still going to get penalized on the full $100,000. If the full amount of the gift is not returned, you will get no credit. You will still be penalized for the entire amount. A partial return is not going to help you. So if you can't give back the full amount, there's no point in giving it all back or any of it back, because you're still going to get penalized. Myth number 7, I can be penalized for every transfer I make in the look back period. That's false. Most transfers are penalized, but there are some exempt transfers. A transfer of a home to a child who for 2 years lived with and provided care to the Medicaid applicant that kept the Medicaid applicant out of a facility. Now, they are getting very strict on this. This is very hard to overcome. If that child had a job during that 2-year period, I can almost guarantee you that this is not going to work, because Medicaid's going to say, well, you couldn't have provided enough care to the applicant because you were also working. That's a tough one, but technically it's exempt. It's in the code. Transfers between spouses are always exempt. Transfers for the sole benefit of a disabled person under 65 into a trust, into a D4A trust, is going to be considered a gift, or excuse me, exempt. Transfers to a disabled child, that's going to be considered exempt. But you have to be careful, because if the child is on SSI and you gift them any money, then they're going to lose their SSI and they're going to lose their Medicaid. Now, if the child is on SSD, then the transfer to that child is not going to affect the SSD payment to the child. So transfer to disabled child are also exempt. Transfer to a sibling who lived in the home for a period of 1 year and had ownership interest in the home. So we've had this occur before, where 2 sisters were on the deed. They were living together. One sister had to go into a facility and was going on Medicaid. We transfer the deed over to the one sister who's remaining at home, and that's an exempt transfer. So some transfers are exempt.
Chris, there's a question.
Okay.
If funds are loaned to a relative via a verbal agreement to repay, do you need to later put the agreement in writing? Will the subsequent agreement be accepted?
The agreement needs to be in writing predating the loan. You indicating that that it's a verbal agreement is probably not going to work with Medicaid. Medicaid is not known for their common sense, for sure, and they have no interest in looking into why something was done necessarily, or maybe other provisions in the law where some things are legal, would be legal in court. Medicaid is going to say denied, and then you can try to appeal that decision from there. But you got to remember that they're very backed up. They have a lot of cases on their desk. They're trying to get through as many as they can, and they're likely to deny it based upon that. So any loan, the promissory note needs to predate the loan. If the loan is dated after, or excuse me, the promissory note is dated after the loan was made, you're probably going to have an issue with Medicaid. Types of trust. We get this question a lot. Clients want trust, but they're not sure why they want the trust. In general, you're either going to have a revocable trust or an irrevocable trust. A revocable trust is simply used to avoid probate. If you don't want to go through probate, you're going to use a revocable trust. It's not going to protect assets. It's not going to shelter anything for you. You are still in full control of the assets that are in a revocable trust. So they're still yours. Now, we use irrevocable trust a lot in our practice in order to protect assets for clients. So the assets that are in an irrevocable trust are protected. Now, certainly we have to do this in certain ways depending on what your current situation is. Again, everybody's situation is going to be different. Are you currently in a facility, or are you at home and you may need facility in a year or two, or are you at home and you're doing well? So each of those scenarios may require us tweaking our plan a little bit, but we do use irrevocable trust a lot. We use annuities too, because if you convert an asset into an income stream, remember the income is not countable. Medicaid does not care how much the community spouse has in income. The community spouse could make $1 million a year, and the spouse on facility could still go on Medicaid, assuming they meet the requirements. So if we can take a certain number of assets, let's say that we take the assets that are in excess of the community spouse resource allowance, and we convert that asset into an income stream by virtue of utilizing an annuity that pays to the community spouse, now we've protected those assets so that the Medicaid applicant can go ahead and go on Medicaid sooner than they otherwise would be able to. And the community spouse now has the ability to protect some of those assets so that they have money to live on the rest of their life, and they're not limited to $130,000 total. The annuities have to meet certain requirements. And I think that's coming up in the next slide. So myth number 8, annuities
Chris,
are not allowed.
There's a question.
Yes.
Is there a dollar amount of assets that make it worth it to establish an irrevocable trust?
What dollar amount of assets is it worth it for you to protect? So if it's worth it for you to protect $50,000, then it's worth it to establish an irrevocable trust. Certainly if you are getting up to 100,000, 200,000, 300,000, it's certainly worth it. I would presume any amount that would exceed the fees associated with preparing the trust would be worth it to protect. So yeah, I think $50,000 would be worth it. Now, if you're talking about $5,000, then no, we're probably not. You're probably not going to be. It's not going to be worth going through everything that we have to do to protect 5,000. But somewhere above, whether it's $30,000, $40,000, $50,000, it's probably worth it. Myth number 8: annuities are not allowed in Medicaid, which is false. They do have to meet certain requirements. It has to be actuarially sound. The annuity has to be irrevocable and non-assignable. The no balloon payments. Actuarially sound means that the term of the annuity cannot exceed the life expectancy of the annuitant. So if the community spouse's life expectancy is 10 years, then the annuity term cannot exceed 10 years. It can be less than 10 years, but it cannot exceed 10 years. The annuity has to name the state of New Jersey as the primary remainder beneficiary, up to the total amount that Medicaid actually paid out. But you're not creating an annuity for an extended period of time, if you're doing this correctly, where there's going to be any money left. So if we're creating an annuity for the community spouse, and the community spouse's life expectancy, let's say, is 10 years, and community spouse is completely healthy, we're not going to create an annuity that's a 10-year annuity. The annuity is going to be much shorter because we don't want there to be any money left for Medicaid to recover. So maybe we can make a 2-year annuity, and then all of the assets that we placed into the annuity, the community spouse will get back in 2 years. So now all of those assets are now protected for that community spouse. It's not countable for Medicaid purposes for the Medicaid applicant. And now the annuity is already paid out and it's dissolved, and then there's nothing for the state of New Jersey to collect on.
Chris, there's 2 questions.
Mm-hmm.
One is, how long does the irrevocable trust have to be placed prior to applying for Medicaid? Have to be in place prior to applying for Medicaid?
It really depends on everybody's circumstance. So if you're healthy and you're doing this and you don't need long-term care for 5 years, then it's the 5-year look back. If you, let's say there's a husband and wife and or even a single person and we're applying for Medicaid, sometimes what we will do is we'll create a trust, we will transfer assets to the trust, and we'll apply for Medicaid. And Medicaid's going to give us a penalty, which is what we want because we transfer the money to the trust. But the penalty period is going to be less than the look back period. And I will still have enough money to pay during that penalty period. Now we don't have an example of the actual numbers of this in this PowerPoint. We have it in another PowerPoint. So what you have to look at is the cost of care minus the individual's income gives you a net out-of-pocket cost. That net out-of-pocket cost, especially if you're in assisted living, is always going to be lower than the divisor. So if we transfer assets into the trust and we have a low out-of-pocket cost, net out-of-pocket cost, we're still going to use the income, and we use a little bit of money from the trust to get us through that penalty period. Once we're through that penalty period, there's still going to be money left in the trust. And then we reapply for Medicaid, and then at that point, we're going to be granted Medicaid. So we can still protect assets even during that 5-year period. But how long they have to be in trust really just depends on each person's unique situation.
There's another question, and it says, is the life expectancy based on the actuarial table? But I'm wondering if the question is, what is the life expectancy based on the actuarial tables?
Life expectancy is based on Social Security actuarial tables, yes. So it's a table that Social Security puts out.
That's it.
Okay. The Medicaid application process, you're going to need a whole host of items to apply for Medicaid. A lot of different, personal forms that the clients have to give to us, which is listed here. You can certainly take a look at that. Proof of income, proof of expenses, asset information, so 60 months worth of banking statements. So whether the account has been open or closed during the past 60 months, they want copies of it. If you've closed one account and opened another account, they're going to want to see the zeroed out account and where that money went. So going into a new account. So if you closed out account at TD and you moved $50,000 over to Fulton, they're going to want to see the zeroed out account and then the new account opened up at Fulton. Life insurance statement of values, irrevocable funeral contract, deeds to real estate. If property has been sold within 5 years, they're going to want to see the HUD. So a whole host of information. What can you expect? If you're filing on your own, you're going to go through the application process. You're going to speak with a caseworker. Once you've submit the application, it's going to take an extended period of time for a caseworker to be assigned. We're talking months. And from there, the caseworker is going to review the file. If any further information is needed, they're going to send you a request letter, and you will have probably in the neighborhood of 10 to 20 days to get that information back. If you don't get the information back, they can deny the application, and then you have to start over again. And if they deny the application, so typically this is a several month process. If they deny the application for failure to provide information, then now you have to file a new application. And during that period, if your loved one has been in a facility, that facility is not getting paid. There's going to be no retroactive payment because you didn't file the application properly. So that's one of the issues that facilities have, is they don't want to admit somebody pending Medicaid if the family is doing the application, because they're not convinced that the family is going to be able to handle the application properly. If there's a penalty period, there's going to be a period of time where there's going to be non-payment to the facility. So those are issues that you need to address. You're not allowed to apply more than 45 days before being financially eligible. Yearly, they will redetermine whether the applicant is Medicaid qualified, so you'll just have to send in updated statements. This part of it's not a big deal. Medicaid appeals, myth number 9, if my application is denied, I will not be able to get Medicaid. That's untrue. You can reapply immediately. So we would suggest, if you're trying to do this on your own, if you get a denial, reapply immediately. And then you can also at the same time appeal your denial by requesting a fair hearing. Whether you're going to be successful or not really depends on why you were denied, whether you didn't provide information or there was a penalty or what have you. So that's very fact specific as well. The fair hearing, you're going before an administrative law judge, so there will be a representative from Medicaid. And if you're doing this, again, if you're doing this on your own, the representative from Medicaid and you will go before an ALJ, you will present your argument, and then ultimately the ALJ will make a decision. That decision then goes to the director. The director then is allowed to uphold the ALJ's decision or reverse the ALJ's decision. So even if the ALJ made a decision that was favorable to you, if it goes to the director can reverse that decision. And then if you want to pursue it further, you would actually have to then take it to the state appellate court from there. So that can definitely be a process. And there's some, we're running close on time. I want to give you guys enough time to ask some questions. The agency has to do certain things when they're going to issue a denial, and it has to be in writing. You can certainly go through this and take a look at it. We have talked about if there's an adverse decision. Estate recovery is where the state of New Jersey collects against a Medicaid recipient's estate. So if they had any assets in their estate when they passed away, Medicaid is going to assert estate recovery. Really, the only time you see this is if there's a home. So if there was still a piece of real estate and the person was receiving Medicaid, then Medicaid will assert estate recovery and they're going to want to get paid back. So it's important not to have assets in the estate of the Medicaid recipient. Otherwise, it's going to be subject to estate recovery. Also, if the Medicaid recipient had life insurance, and again, we could do a deeper dive on life insurance because there's other things that go along with it. But if there's not a named beneficiary, then it's going to be payable to the estate of the decedent, which is the Medicaid recipient. Medicaid, or the state of New Jersey, can collect against that as well. Medicaid will, myth number 10, Medicaid will take all of my assets immediately after I pass away. That's false. They cannot seek recovery if there's a surviving spouse or a surviving child who's under the age of 21 or blind or permanently and totally disabled. In that case, repayment would be just postponed until the child reaches age 21 or the death of the spouse. So that's also why it's very important not to have real estate in the name of of the individual where they can recover against that.
Chris, there's a couple questions. Oh,
Okay.
we're finished. Okay. So one question is, our elderly, widowed, childless aunt lives alone in Tennessee. If she liquidates her assets and is able to be a full pay resident at Spring Oak in New Jersey for a couple of years, when her money runs out, can she apply for Medicaid to remain at Spring Oak? She has no need to leave anything to anyone upon her passing. So that's a question for you and for Matthew, really, but yes.
Yeah, if she's residing at Spring Oak and she meets her private pay requirements pursuant to what they want. So if Spring Oak says we want 2 years of private pay, if she pays her 2 years and then she runs out of assets and now qualifies for Medicaid, then yes, she can go on Medicaid in New Jersey.
Right. This is actually a question that we get a lot because people like to wonder what happens once they do run out of money. So Spring Oak only requires a 1 year of private pay. And then after that, you can apply for Medicaid.
And that's where what Chris is talking about, having that deeper dive into qualifying for Medicaid. So even though you've paid that 1 year and even though you have spent down your assets, or the 2 years and you spend down your assets, we still need to look back those 5 years and make sure that you're going to qualify, that there haven't been gifts and all of those things. Do you need a qualified income trust? So all of those things need to be looked at before it can be like a complete yes, but those two specific questions are yeses. The next question, Chris, is what effect, if any, receiving Medicaid have on an applicant's health insurance? Will they be forced to drop the insurance they have and accept a Medicaid preferred health insurance?
I'll leave that one for you.
Yeah, I was just gonna say I should answer that. So it doesn't affect anything, especially if you're in a facility. The only possible changes in a facility is that you have to move to a shared room when you're on Medicaid. And that's not every facility. They'll tell you that when you, tour or move in. Like Matthew would be the person to explain. Once you're on Medicaid, you may need to move into a shared room or maybe a different room. As far as the insurance, your Medicare, if that's your primary, stays your primary insurance, and your Medicaid, so you're a Medicare and a Medicaid are your insurances. Most physicians accept Medicaid. If they don't, then you would need, the case manager for Medicaid would help you find a Medicaid appropriate physician. But I mean, it's very rare that somebody does not accept that, because you have your Medicare or your Medicare supplement, whatever your primary insurance is now, will stay your primary insurance for physicians, for hospitalizations and things like that. Medicaid picks up things like transportation, medications, eyeglasses, paying for the facility, or paying for care at home if you're staying at home. If a couple is separated but not divorced, is an affidavit of separation sufficient for Medicaid?
This is a little gray with that one. Medicaid likes to see the divorce. Sometimes they give us a hard time, sometimes they don't. It really depends. But if the couple is divorced, or separated, and has been separated, and they've been living apart, and their assets are separate, sometimes Medicaid will just say, give us an affidavit, and they accept it. Sometimes they want to see the assets of that spouse that's still there. I would make the argument that they're not entitled to see those assets. They have been legally separated for an extended period of time. There's also something called spousal refusal, where that spouse refuses to provide any information, provide any care for that Medicaid applicant. So that's a little bit gray, but if they're truly separated, I think we would have a good argument that the assets of that spouse would not be subject to Medicaid scrutiny.
Thank you for this presentation. It was very informative. Also, thank you for the sweet, yummy chocolates. Please pass our thanks on to Matthew as well. Are there any situations where a resident could be forced to leave Spring Oak, health reasons primarily, and if they have to relocate, is the Medicaid recipient then limited as to what long-term care facility they can move to? So I'll answer the second half of that question, and I'll let Matthew answer the first part. So as far as limited to the long-term care facility, if they're already on Medicaid and they're approved for Medicaid, then we just have to find a facility that has a Medicaid bed. Most assisted livings only accept 10% of clients on Medicaid. And also you have to have that private pay requirement. Long-term care facilities like nursing homes, they would most likely have that. Now, if they have a private pay requirement first, it's going to depend on what their Medicaid numbers are. So as far as being limited, it really depends on where you're looking to go. And it really also depends on their census. But you'll be able to find some place to go. That's not a problem. And Medicaid also helps with that. And then Matthew, you can answer the first part of that question.
Right.
Do you
So
want me to repeat it?
Yeah, it was them being forced to leave
Correct.
Spring Oak.
Healthcare reasons or Medicaid.
Right. It would mostly be healthcare reasons. Like once we feel like we can no longer keep a resident safe within our community because our level of care only goes up so high. Once a resident needs a higher level of care, then we suggest to the family, hey, we think maybe it's time to look into long-term care, and we can kind of help you find a place that's best suited for your loved one in that regard.
Mm-hmm. And Matthew helps with that. And I can tell you that it's so uncommon in assisted livings when that happens because they want that to be your home forever.
Right.
Hospice can come in, you can bring in those extra third-party vendors to help with that extra care as needed, but they really want you to be able to age there for the rest of your life. So it's not super common. If that person is a harm to themselves or someone else, that's really where it becomes a major issue, I think.
Yeah.
And
So I wouldn't say so much as force.
Right.
We try to go
Yeah, it's not
through all the
forced.
options. Right.
There's a conversation, a care conference meeting, things like that.
Right. There's a long process before we're like, hey, we can't take this person anymore. So we try to go through every option before moving on.
And then the next question is, can you review the Medicaid income limit on the Medicaid patient versus the income limit for the healthy spouse?
The Medicaid limit for the applicant is a little over $2,300 gross per month. If their income exceeds that amount, then they need the QIT, the Qualified Income Trust that we spoke about. There is no income limit for the community spouse, the spouse that's remaining at home. Medicaid does not care what that community spouse's income is.
So it looks like that's all for the questions. Oh, wait, one more. Is the level of care provided in either Spring Oak or a long-term care facility affected by Medicare? I'm assuming you mean Medicaid. Is there less care provided? I do not think this is the case with Spring Oak. So no, it would be illegal for the care to be less because their insurance changes. It's the same thing if you go to the hospital. They're not going to say, the private pay people over here and the Medicaid people over here. It should be the same care, the same level of care, the same physicians, the same staff, and that should be across the board. And that doesn't change as well at Spring Oak or any long-term care facility. Again, the only thing that I really see potentially happening is potentially a shared room, depending upon the facility, their census and needs. So while we wait to see if we have any more questions, Chris has offered for anyone that's on this call that would like a free consultation. We're happy to do that with you. You can call our office. I did put that in the chat, but I can tell you the number now if anybody wants to write it down. It's 856-857-6007. We have 5 offices that we can meet, or we can do a face-to-face. We can do a phone call. We can do a Zoom call to help try to answer some questions that are more personal to you, since a lot of people seem to have specific questions about what's going on in their life. And Chris was explaining that some things are really very different based on what your story is. Spring Oak provided excellent care for my father-in-law and mother-in-law. That's nice. Somebody wrote that too, Matthew.
What?
I'm going to butcher his name. Brozina is the last name. Thank you for your time today, he said as well. Thank you. So again, thank you to everyone for being here. Thank you to Spring Oak for sponsoring this event. Hopefully those of you that came and got your treats enjoyed them as the Servones said they did. Thank you to Chris for your expertise. Again, if anybody has more questions, please don't hesitate to reach out. You can reach out to Matthew or to us at Bratton Law. We're happy to help. We know that these are questions that are constantly coming up and they're hard to remember and hard to explain. And again, it's different for everybody. But the most important thing is to get the information so that we don't make those mistakes moving forward, so that we can get that care and that payer source for your loved ones. Matthew, Chris, anything else you want to say?
Well, thank you everyone for participating inside of the webinar. I thought it was very informational just for me. We do get a lot of calls, so it kind of helps me answer some of those that come in. If you guys do have any further questions, feel free to email me or give me a call. I did put my information inside the chat, so I'm available anytime, Monday through Friday.
All right. Thank you again to everybody. Please stay
Okay.
safe out there. Take care.
Thanks, everyone.
See you
Take
soon.
care.
Bye.